Good afternoon and welcome to the Appellate Division First Department. Can we blank out that screen until that case is called? Thank you. So we have 5 hours of argument time requested, so I'm going to ask everyone to ask for the time they actually need, not the time that you want, understanding that this court is fully familiar with your case, the briefs, etc., normally more than you wish we were. So please limit your time request to what you actually need so that I don't have to cut it for you. Understand that the time limitations are on you, not on the court. So if my colleagues have additional questions, because your argument is so brilliant, I will allow the questions to continue. Okay? All right. People versus Fernando Ponce de Leon. Submit. Patterson versus 786 East 182. Okay. 4 and 2 and 3. Thank you. K. Hine versus Fakal T is submitted. Ward versus Times Square Hotel. 4 and 1 and 4. Luftilla versus Services for the Aged, and forgive me if I have mangled the name. You weren't listening. Go ahead. Neither were you. 5 and 1 and 5. People versus Sherman Walker. Okay. 5 and 1 and 5. LRB versus 61 West 62 owners. Okay. 3 and 1 and 3. Justice Backer versus Abeles. Okay. I don't believe that the other side has asked for any argument time.
Wait, that's,
Oh, I'm sorry. Yes.
Hi, yes. Yeah, I will, if you don't mind, 5 minutes for me.
Okay. 4 and 1 and 5. U.S. Bank. Okay. I'd say 5 but 4, Your Honor. 3 and 1 and 4, and don't worry, if they have questions, we'll get to 5. Okay. 239 East 18th owners. Appellants first. Go ahead. Okay. Well, you're not both getting 10 and 5. Since there's a cap, let me finish, there's a cap of 15 combined, and I don't think that this requires 15 minutes, so. I see. Okay, got it. All right. I haven't determined yet. And you, 3. Okay, I'm going to do 4 and 2 and 3. Okay. Preti versus J.J. Hoyt. Okay. 5 and 1 and 4. Archdiocese of New York versus Century Indemnity. Okay, I granted both of you 4 minutes, period. So if you'd like your 4, 3 and 1, I will do that. Okay, 3 and 1 and 4. Okay? And Lutima versus Liberty Coca-Cola is submitted. First case on the calendar is Patterson versus 786 East 182nd Street. You may proceed.
Good afternoon, judges. My name is Robert Von Hagen. May it please the court, from Molad Spitz and DeSantis for the appellant. This is a slip and fall on what the plaintiff called watery ice. The defendant submitted an unrebutted meteorologist's affidavit coupled with certified data demonstrating there was an ongoing storm of freezing rain starting from the day before. The temperature dropped that afternoon at 2 o'clock, resulting in a slick over of the surface throughout the entire neighborhood, the entire area, including the courtyard where my clients.
Testimony from the super.
The
Correct?
super testified that there was, quote, pure ice falling from the sky, not just earlier in the day, but even at the moment of the fall when his own wife fell in the street, an area that he's undeniably not responsible for.
Now, wasn't the super doing some work, even though the storm was going on? He was doing some cleaning work during that period of time.
Yes, Judge, and this court's decided other cases where when landowners gratuitously undertake snow removal services, that's something we encourage, it's something we want to do. He had moved sleet when the storm started at around 2 in the afternoon, early afternoon, 4 o'clock, and then followed up with throwing down, quote, lots of salt. This court has decided that that is not sufficient to show that they created or exacerbated any dangerous condition. In my opinion, that's exemplary snow removal services that's done as a preventative measure in advance of anything happening. And then he continued, and he was on the sidewalk doing the same thing while the other areas of the premises were being rained upon with what he called pure ice. So I think this fits squarely within the storm in progress doctrine. There was no rebuttal to the meteorologist's affidavit, and there was no evidence submitted to suggest that the plaintiff slipped on anything other than.
So plaintiff failed to raise an issue of fact.
Absolutely, Judge.
I believe my colleague has a question.
What about the handrail issue?
I think the plaintiff abandoned that in the respondent's brief to the extent that it is mentioned. It's purely speculative. The plaintiff affirmatively said that she had no problems with the steps. She had lived there for 10 years and had no complaints about the steps. We submitted an expert affidavit showing that it wasn't required under the applicable code anyway, and he actually said that his own opinion was gratuitous because the plaintiff would need to have been turned around, grabbing backward in the direction she was walking, and the handrail, even if it had existed, would have terminated beforehand. So pure speculation to say that it would have caused or arrested her fall, or that she would have even grabbed it. She actually said that she had let go of the wall that had been steadying her to depart onto the courtyard where she ultimately fell.
And did the plaintiff put in any responsive expert affidavit?
I wouldn't say it was responsive. There was
To
an
your-
expert affidavit that I think is inadmissible based on a number of frailties. I don't think Mr. Ketchman is qualified to render an opinion in the case. He did not conduct an inspection of the stairs. He says that his foundation is based on a visit to friends at the property. That's not an engineering.
Did he mention anything about the handrails issue?
He mentioned it, but he did it in the context of applying the wrong code. And the decision of which code applies is a matter of law for the court. He applied the 1922 building code, which actually references back to the Tenement Housing Act of 1901. It's express in the text of the 22 code, and that's what our expert relied on, which was the applicable code. This is a residential apartment building, and it is brought under the auspice of the Tenement Housing Act, not under the commercial construction that was contemplated by the 22 code.
With respect to the storm in progress doctrine, didn't the plaintiff testify that it was not snowing at the time?
This court, there are 2 points of law to address that testimony. This court has mentioned in the Lowenstern case and others that when you have this objective data from the Climate Data Center, it's actually a matter of statute, that the facts stated therein are prima facie evidence of the weather going on at that time. And it overwhelms. I think the plaintiff's testimony is a perfect illustration of why this court has that rule. She was looking down, observing ground conditions. It was night. She had only been outside momentarily. The testimony is inherently unreliable to begin with and insufficient under this court's precedent to rebut the climate data.
Thank you so much.
Thank you, judges.
Good afternoon, and may it please the court.
You may want to lower that mic a little.
Just a little. I don't know. I'll be
wanna make sure we
freakishly
hear you.
knowledgeable here. My name is Denise Rubin. My firm is Rubin Law, PLLC, appearing for for plaintiff respondent, Ms. Patterson. Ms. Patterson first testified not only that she didn't see any rain falling or sleet falling when she came out of the building, but that she knew it wasn't precipitating when she left because she has an air
The
conditioner.
problem is that we have a expert who says that there was sleet falling at that time. So,
Understood, Judge, but his opinion is somewhat
his
different.
opinion is based on meteorological facts and data.
Not exactly, Judge, respectfully. His opinion was said he cited the data, he cited the National Weather Service. The National Weather Service, for that day and time, had put out what they call a winter weather advisory. He mentions that, and then the rest of his affidavit talks about a winter storm and a winter storm.
So what do we do with
These are two
what do we do with the superintendent who says that at the time of this accident, he is clearing sleet from around this building and that his own wife fell right around the corner? So this isn't just the expert. We also have a live witness who contradicts what your client says. So I have an expert and I have a witness who says it is sleeting at the time. And I think you and I can agree that if that fact is correct, then your client is out. Because that is a storm in progress. Can we agree on that? That if
Respectfully, no,
these,
Judge.
huh?
That's not a storm in progress according to the terminology used by the National Weather Service.
Okay.
They very specifically.
How about our case law? What does our case law say about a storm in progress? Because that is what is controlling here, not what the weather department says constitutes a storm, right? Right? Our case law.
Understood, Your Honor.
Okay.
At best, I would say that is a question of fact. You have testimony of one person versus testimony of another person,
And the expert.
and the expert whose testimony, in our opinion, is questionable based on his failure to follow what the National Weather Service is talking about here. You know, it becomes what constitutes a storm? A little rain, a lot of rain, 6 feet of snow? I mean, at some point, you have to say this is drizzle versus a storm.
Okay. You have 2 minutes.
Thank you, judges. I'll be as brief as I can. On page 248 of the record is the certified data that the expert relied upon. So this is not an unfounded opinion. And if you look at lines 3 and 4 of that data, you can see the specific amounts of freezing rainfall and precipitation from the day before at 7 a.m., proceeding all the way through the next day, up until the point of the plaintiff's accident, which is when trace amounts of rain were still falling.
Did they submit an expert report from a meteorologist?
No.
Contradicting that?
No, this was unrebutted. It's not just testimonial evidence in an affidavit. This court has other cases where it's sufficient to submit just the certified data, and that's under the CPLR. I forget the specific statute. It's Article 45. But the legislature has determined that this evidence that you see at 248 is prima facie evidence of the facts stated. So there should be no question there was a storm in progress occurring, regardless of the plaintiff's observations in a partially protected area at night for a few moments, which again is rebutted. This evidence that we've submitted is corroborated by the superintendent's testimony. It's not simply a he said, she said situation. So the court has decided a summary judgment in favor of defendants on less than what's in this record.
Thank you.
Thank you, Your Honors.
And we are going to call now K. Hine versus Fay Cal T. Apparently, there was someone in the courtroom who didn't realize that case was being called.
Good afternoon. My name is Paloma Rivera from Paul Weiss, Rifkin, Wharton, and Garrison LLP, and I represent the respondent in this case, Dr. Hind Katani, who's the mother of Elias Tahiri. We are mindful of the fact that Dr. Tahiri and the children's attorney have selected not to argue today, and we are also mindful of the court's time. We are happy to answer any questions that the court may have based on our submission. Otherwise, we are happy to concede our time.
Any questions?
Nope.
You got it.
Thank you so much.
Ward versus Times Square Hotel. You may proceed.
Good afternoon. My name is Tracy Frankel from Malaparo, Prisco, and Clauber, and I represent the appellants Pavarini McGovern and Times Square Hotel LLC. The record here is rife with credibility issues that should have prevented the plaintiff.
Credibility, an issue that on summary judgment, the court is supposed to be entertaining?
Well, credibility, if it exists, has to.
Because your credibility issues are based on omission. You don't have anyone who's saying anything different than what the plaintiff is saying. So your basis for arguing credibility is based on speculation, conjecture, arguments. No live testimony.
In cases where, as here, the record facts are inherently inconsistent with
They
there
are not.
being ice.
How are they inherently inconsistent?
For example, there was no precipitation that day whatsoever. The plaintiff used those same stairs 4 times within 2.5 hours. There
That
was
doesn't
0
matter.
ice.
It's getting cold throughout the day. The temperature here, and it was unrebutted that it was under freezing. So, continue.
The superintendent said that where there is no precipitation, there's no water to form into ice. Plaintiff took no pictures, and plaintiff actively prevented.
You took no pictures. So
took no
someone
pictures.
falls, continues to work, and they're supposed to stop and go and take photographs. That's the argument.
Look,
The lack of evidence, because his testimony, his statement that he fell is insufficient.
He actually did stop working for about a half an hour, where he could have taken photographs of the alleged ice and did not. But
Counsel, didn't the meteorological records submitted indicate that the outside temperature for 50 hours leading up to this accident remained at well below the freezing point?
there was no precipitation in the records that were provided, not to mention the fact
So it was not well below freezing 50 hours prior to the accident?
there may have been freezing weather, but there was no precipitation to form ice on the stairs of the building. And it was irresponsible for someone who had never observed
The
it.
stairs exposed to the elements, correct?
Yeah, there were no walls, so that is true. But Mr. Wright claims that he submitted his affidavit and yet reviewed the records somewhere after. So his affidavit that was submitted in support of
difference
those
does that
records
make?
was in.
What difference does that make?
Well,
Where he reviewed.
his affidavit was incredible on its face, because you can't base your opinion on records you review after you form your opinion. That's number one. Number two, he didn't inspect anything and could not have, because he was retained much later than the events in question. And so to indicate that there was ice on the stairs, and ice where the plaintiff states that he fell, that's an issue. Additionally, the plaintiff claims that he has a witness that testified that there was ice where he fell, except the witness disputes the location of the fall. And if there is no ice where he fell, then 1.7 of the industrial code doesn't apply.
Thank you.
Thank you.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. There's no...
Counsel, can you pick up on that witness thing? I'm sorry, I talk loud.
Oh, no worries at all. No, not loud at all. Not loud at all. It's all... Sure, of course. I was going to go
She's
over...
saying that this witness, can you pick up on that?
Sure, of course. If you look at 312 of the record, and in defendant's brief, I don't know if it's convenient, but they certainly omit the relevant testimony, which is as follows. Question. This is of Mr. Hughes, who's, by the way, 10 to 15 feet away from the staircase, has unobstructed view of the stairs. Question. Do you recall seeing any ice on the stairs in that area? Answer. It was definitely icy, yes. So, as you say icy, what makes you say it was icy? that time of the year, it's exposed, and like I said, any kind of light rain or anything goes through there, it's basically hitting the staircase. And generally, there's a lot of traffic up and down, so it builds up with grease and ice. It's definitely a problem. 312 of the record. So he corroborates it. Even if we didn't have Hughes, they didn't provide anything to dispute.
And he says, this is a witness who's in another area, sees this man fall, goes to him, and wait, and the man doesn't want to stop working. He like, let me just gather myself. And he pulls himself together and continues to work,
Correct.
right? But there is no daylight between what this witness says and what the plaintiff says. Am I correct? Have I misstated anything in the record?
Perfect. One other thing before I sit, which I think is really important, I'm sure you've figured this out, is that the testimony of Mr. Brophy actually establishes a propriety of summary judgment to plaintiff under 1.7D, and here's why. So this is Pavarini's witness, Brophy, at 235 of the record. He actually admits that because the stairs are open to the elements, there's nothing we can do. If that's not the epitome of failing to provide safe footing under 1.7D, I don't know what there is. Of course there's something you can do. He testified that if it were to be icy and if there was snow, I'd make sure it was taken care of. Nothing was taken care of. Neither plaintiff nor Mr. Hughes saw any ice or sand on the stairs.
And we know it's clear. You know, this state is replete with case law on how to deal with snow and ice. It's called salting and sand.
That's correct.
Salt to melt, sand to create traction. It's simple. It doesn't take a rocket scientist.
That's
right?
correct.
And if you put salt and you put sand on an open stairwell, that salt and that sand continues to work.
Which is what Mr. Wright actually explains in his affidavit, and he says, had salt been put down, and to your point, Judge Rosado, that there was 52 hours, according to Mr. Wright, it was 52 hours of temperature before freezing, a couple days after a 5.6 snowfall, where there was, so it was freezing, and had they applied the ice, in Mr. Wright's opinion, which is unrebutted, it would have prevented the ice from falling.
So there's no relevance, in your opinion, to counsel's statement that there was no snow and ice that day or the day before?
Correct. And to that point is because this staircase remained open to the elements. So even though it wasn't precipitating at the time, we're not disputing that, there was a freeze and thaw, as Mr. Wright explained, but also 52 hours prior to this incident, after a heavy snowfall, it was below freezing, and when you have that in conjunction with Mr. Brophy admitting, there's nothing I can do because it's open to the elements, we usually don't do anything. So prima facie case was established, and this court should affirm. Thank you.
Thank you.
Just a couple of things to
have
add,
1
Your
minute.
Honors. Okay. With respect to the testimony that there was nothing they can do, I would mention that the court had already held, and that hasn't been appealed by the plaintiff, that there is evidence that the defendants were reasonable in what they did do, which was a site safety manager walking the job daily, which is the superintendent's walking the site daily, which is whenever there are icy conditions or snow, they are salting and
Walking
putting
the site
sodium
daily
chloride.
without doing anything to the steps is meaningless. Oh, look, it's freezing. Let me put that in my notes. If you don't do something about the icy condition, it's meaningless.
Right, but here there was no evidence of an icy condition, and there
That's
were
not
no
accurate.
complaints of it.
Because,
Well, it is, there were no complaints.
Counsel?
May I?
Sure.
My understanding is that expert Wright opined that at 5:30 a.m. on January 10th, when the temperature was at 32, snow melt could have occurred dripping onto the staircase that was open, so that you can have a snow melt and the situation remains constant, even though, as my colleagues pointed out, there was no precipitation on the very day of the accident. So that's not accurate, and that's based on climatological records that you have encountered.
What Your Honor is stating is what potentially could happen, not what was present.
It did. He's saying snow, okay.
Additionally, my last point,
I'm gonna give you 30 seconds because you're out of time.
Thank you. I just wanted to address the fact that where a plaintiff actively prevents an inspection from a defendant, it irreparably harms the defendant and places them in the very scenario we have here, where Your Honors mentioned that the plaintiff is the only person who
How did the plaintiff
who testified.
prevent anything here?
Well,
The argument is if the plaintiff prevents, what evidence is there in this record that the plaintiff prevented the defendants here from checking this open staircase? What?
well, there's no evidence they didn't. They-
Precisely. Thank you.
No. There's no.
Thank you. People versus Sherman Walker. No, I'm sorry. Lutifia versus Services for the Aged.
Good afternoon.
Good afternoon.
May it please the court, my name is Kenneth Kirshner. I'm a member of Hogan Lovells, and we represent defendant appellants, who will be referred to collectively as JASA. We want to make the following 3 points. First, the trial court erred in relying on the dicta in 2 distinguishable cases, Smelly and Desura. Second, the lower court misconstrued section 652.3b and virtually ignored 652.3c and the regulations 143.4 regarding revocation of the exemption by the commissioner.
Sir, would you agree that you did not competently meet, at least on this record, and if I make a mistake in knowing the record, please correct me. Did you establish on this record that you comply with the prevailing minimum wage obligations? Just bear with me, because the statute doesn't make you off the hook. Did you establish, at least with these plaintiffs, that you provided a minimum wage, prevailing minimum wage here?
In the record, Your Honor, and I'll
No, when you pay a certain amount of, a certain number in an 8-hour shift, when they work more than that, how did you establish that you covered when they worked overtime? How did you establish the spread of hours, wages? How did you establish all that?
Well, these employees were not entitled to a spread of hours under the certification.
So they get to work 24 hours and you spread out the hourly wage over those 24 hours, which goes below the minimum wage, and you think that's okay?
I didn't say that was okay, Your Honor, but that's up to the commissioner to
You are,
determine.
no, it's not up to the commissioner. There is a minimum wage,
Yes,
and that must be paid.
and we did pay the minimum wage.
Not if it's 24 hours and they're being paid the minimum wage for 8.
Your Honor,
That is not 24 hours worth of minimum wage payments.
there's a difference between paying minimum wage for the hours that were submitted, which were the only hours submitted by
So
this
these
plaintiff.
workers are slaves?
No, they're not slaves.
They should work for $8 an hour over a 24-hour period? Is that what you are arguing?
That's exactly the case in the Hitches case, where they said, claimed that they were getting half the minimum wage, and the court said, go to the commissioner and see whether or not the certification
So the
still
commissioner
applies.
gets to decide whether they abide by a federal minimum wage requirement?
There's no claim under federal law in this case.
How about the state?
Und-
Our state has a state minimum wage requirement.
Correct.
So you're saying that this commissioner gets to override the state legislature?
No,
Is that what you're saying?
no, the commissioner gets to decide whether we're complying, whether, or our
So
client
in other
is
words,
complying.
the commissioner gets to ignore the legislature's requirement that every worker in New York City and New York State get paid a minimum wage.
Not true. What,
Did these workers who work 24 hours and got paid only minimum wage for 8, did they get paid minimum wage for all of the hours they worked?
yeah, there's nothing in the record that they ever submitted claims for those hours, number one. Number
That's
two,
not an answer to my question. My question was, did they get paid minimum wage for the 24 hours that they worked?
there's nothing in the record that says that they actually worked 24 hours.
Oh, so now we're disputing that.
Well,
Got it.
that's
I
up to the
got it.
commissioner.
Go
That's
ahead.
up to the
You
commissioner.
go right ahead.
Yes, that's only an allegation in the complaint. And for purposes of the motion to dismiss, we have to assume the facts are correct. But ultimately, under 652(3), this case has to go to the commissioner to decide whether our client was in compliance with the minimum wage law. This is a statute that is very unique in the circumstances of the law. It only applies to not-for-profits and
Perhaps
only
the
those.
legislature should look at this again.
Well, they've made exceptions for not-for-profits on a number of occasions because of the salutary effect of not-for-profits. And they've made exceptions, like in 191 of the statute says not-for-profits don't have to pay weekly, they could pay bi-weekly. There's a provision in the unemployment law that says they could self-insure. And there are other exceptions for not-for-profits. This is one of them, and the commissioner grants an exemption for these not-for-profits. Very few not-for-profits are subject to this. I don't know the exact number, but you have to file for the exemption within 6 months, and so very few have actually received that exemption.
Thank God. We'll hear you later.
Thank you.
May it please the court, my name's LaDonna Lusher. On behalf of Virginia Nambinder, I'm here
Did
representing.
have I missed something?
No,
But did these workers work 24 hours and got paid only 8 hours at minimum wage?
13 hours. They were paid for a total of 13 hours
At minimum wage.
at the minimum wage, and
So the other
11.
11, they didn't get paid for at all.
That's correct, Your Honor.
And so when we compute that, what does that actually mean?
It
What
ends
was their actual hourly salary when you divide the actual hours worked, which is how we pay people in this country? You work an hour, you get an hourly wage if you are an hourly worker. So tell me, how much did these workers get paid for their 24 hours of work?
It's approximately about $8, and I think it's 67 cents per hour.
And how much is our hourly wage?
Well, at the time, roughly $15 an hour, but depending on the year.
So they've been cheated almost half.
Correct. That is correct.
Counsel, your friend made a point of saying that everything is up to the commissioner. My understanding is that you had the right to go into the Supreme Court and seek the relief you're seeking here without having to exhaust your administrative remedies. Is that correct?
Absolutely, Your Honor. In fact, for nearly a century, workers have had the right to go into court to claim their unpaid wages, and there's a plethora of case law.
And that the fact that the other side is a non-for-profit doesn't change that right.
That's correct. And in fact, I think it's really important to look at the title of that statute that they are claiming that the exemptions under, and particularly if you look at the New York Code Rules and Regulations, the title of Section 143 is Minimum Wage Requirements Applicable to Not-for-Profit Making Institutions which have elected the option to pay the statutory wage exclusive of allowances in lieu of being covered by the minimum wage order. So before you even get into the requirements of what that means, you have to look at the statute itself, which says, okay, we've elected this option because we've agreed to pay the minimum wage in lieu of being covered by the wage order. And you don't have to go to the commissioner if you're a worker who's claiming that you were unpaid, to say you were unpaid. Workers bring cases all the time in court. This court has rendered countless decisions for workers that have come to say that they've not been paid their overtime or they've not been paid their minimum wages.
I mean, the whole, isn't sort of the status of this particular motion was a motion to dismiss by the defendant because they said that they were exempt from, exempt because of this labor law provision, right?
That's absolutely correct. And so all the trial court did was to decide that their certifications, quote unquote, it's really their forms that they filled out saying that they were going to pay the minimum wage, which, by the way, on page 30.
And let's be clear, that certification was dated June 14th, 1977.
And there was another one in 1984.
Before.
And the one that's on page 36 says that they didn't even have employees at the time they filled it out. So how do you declare under oath you're going to pay everybody minimum wage and you're going to continue to pay? We don't even have employees at the time you fill out the form.
Now, is there a process by which not-for-profits recertify their not-for-profit status?
Well, I do believe that my adversary points out that the commissioner does have the right to look into this exemption if somebody makes a complaint. But it's not the...
No, my question is there a normal procedure after someone is licensed as a not-for-profit, right? Is there a procedure? Is there some requirement that they provide updated information on any kind of interim basis to continue to establish they truly are not-for-profit? Because, I don't know, I looked at the record here and there were a lot of documents that showed lots of millions of dollars.
That's correct.
That doesn't sound like not-for-profit to me. So it seems to me like that's an issue of fact, whether even that basic criteria has been established here.
I agree with Your Honor. I think that's, first of all, to answer your question, no, there is nothing that they have to show.
They don't have to renew their license every X number of years in this particular context.
No, they make the certification, the self-election in 1977 and 1984, and the only time it gets questioned is if you have a worker that brings a case saying you didn't pay me. And we cited other cases where this particular employer was sued multiple times from other employees claiming that they weren't paid correctly also. And if I could just indulge one more thing, I just wanted to say that to their argument about the commissioner being the exclusive authority, there's nowhere in the statute that it says that. And in fact, the section C that they point to, they don't cite this in their brief, and it's important, and I'll hurry, but at the very, very last sentence, this says that in no event shall any order of the commissioner discharge the obligation of the not-for-profit making institution to pay the statutory minimum wages for any period prior to the issuance of any order. So it doesn't matter whether the commissioner issues an order to revocate or not. What matters is that they have an obligation at all times to pay the statutory if they want to try to claim this exemption.
Thank you.
Thank you.
You have 1 minute.
That provision says that the commissioner has to provide for the amounts, not the court, number one. Number two, plaintiffs are seeking spread of hours and overtime under 142, which specifically says that this part shall not apply to employees of not-for-profit making institutions which have elected to be exempt from coverage under minimum wage and the subdivision 652.3, which is what our client has. So this provision, which is relevant to all four of the complaints, causes of action of the complaint, does not apply.
Except that if this court determines that the record is unclear, that you have satisfied the very first prong of being a not-for-profit, then it seems to me that it is an issue of fact.
Your Honor,
you will have
Your Honor,
time.
the complaint itself says that our clients are not-for-profit. So the complaint by itself does.
Thank you.
Thank you, Your Honors.
People versus Sherman Walker.
Good afternoon. For Mr. Sherman Walker, Office of Appellate Defender by Christiana Prater-Lee. Mr. Walker's plea was not knowing, intelligent, and voluntary, where he was not fully informed of his right to mandatory discovery and two of his three Boykin rights. Under Criminal Procedure Law 245-75, the court shall inquire on the record to ensure that a defendant understands his right to discovery and right to waive that discovery. That law is part of the 2019 discovery reforms, which were intended to provide full discovery to criminal defendants, and particularly under 245-75, which was amended in 2020. That is intended to ensure that defendants don't take pleas in the dark without understanding the full value of the discovery in their case. Here, without this advisement and without full discovery, Mr. Walker was left in the dark. Discovery was important to him in his case.
His lawyer did say at the time of the plea that he had received, albeit that morning, all of the discovery, right? He did say that, correct? And at no point did counsel say to the court, since I just got it today, can we put this over to tomorrow so that I can take a look at it and talk with my client about it? So it was on the record that the discovery had been received that morning. That's on the record.
It's also on the record that prosecution said that they did not turn over full discovery. A Giglio material was remained
I think what he said was that really what was missing was a document which was a certificate of compliance. It was like, I'm not going to quibble with you. I know that there were last-minute documents sent that morning.
Last-minute documents, Your Honor, were sent
Yes,
that morning.
discovery, yes.
And there's discovery still remaining
And the
outstanding.
attorney put that on the record and counseled his client to take this plea.
Counsel told the court that it was hard to advise his client whether or not to take the plea. And
Did
at that
counsel
point,
ask for an adjournment to review those records before taking the plea? Did he make any motion after taking the plea saying, now that I've had an opportunity to review the discovery I received last minute, I want to reconsider because I think there is something in those records that my client should have known about before taking the plea? Was there any of that?
the court made clear.
Was there any of that? And then you can say whatever you want. I need you to answer my question.
There was no record that the council made any post-statement motion.
The defendant was sentenced 3 months after his guilty plea, correct?
Yes, and in that
And he
time,
could
there
have
was
objected and said no. And at sentencing, he didn't raise any issues or contest the validity of his plea.
And
in his 440 motion, he didn't challenge any of the issues he's challenging now, correct?
That is correct, but I would point this court to the Court of Appeals decision this year in People v. Smith, where there's a mutual misunderstanding as to the rights being conferred. No one mentioned his right to be advised of his full mandatory discovery. Where there's a mutual misunderstanding, a defendant cannot be expected to know of the rights he's waiving. He was not expected to know of his right that he was waiving here because the court never did that inquiry. I would also point this court to the model inquiry, model colloquy that's been in place since 2020 as to 245-75 waivers, and that was not done here. That's all the court had to do was inform Mr. Walker of his right to discovery. Because that was never done, Mr. Walker's plea cannot be.
The fact that his lawyer talks about discovery having been received that morning doesn't put him on notice that there's discovery requirements that have been dealt with?
Counsel also talked about discovery remaining outstanding. The prosecution admitted that that Giglio material was never disclosed, and counsel told the court that it was hard to advise Mr. Walker of the plea. There was no inquiry into whether or not that
This wasn't your client's first plea, correct?
His last plea was in 1992.
So he had several pleas, including prior to 1992,
And
correct?
those were long before the discovery reforms required him to be advised of his right to full discovery under 245-75.
Counsel, is it my understanding that his counsel was able to get him a continuance between the plea and the sentencing so that he could have more time with his family? And there was a sufficient amount of time for you to come in and seek to vacate the plea before this appeal, correct?
Basically, there was no record that he had known about his right.
His lawyer knew. His lawyer put it on the record, counsel. His lawyer said it at the time of the plea. I got discovery today. So again, I say to you, if there was I am open to this argument, okay? But if there was something in that discovery that defense counsel thought, man, I should have known about this before I let my client take a plea. I don't see that in any of the papers. There's nothing. There's just There was discovery and I didn't get it, okay? There's gotta be something more, no?
Counsel didn't know what was in that discovery. He tried to
And he
ask.
knew by the time of sentencing, because 3 months had elapsed, and he did not make a motion to withdraw,
Because he didn't know of this right,
because he didn't know what?
of his right under 245-75 to
His
be
lawyer
asked.
did though, but I'll hear you on rebuttal.
Good afternoon, Your Honors, and may it please the court, Juliana Susu for the people. As an initial matter, defendant's plea voluntariness claims are unpreserved. As this court was mentioning, there was...
Counsel, look, we could avoid all this if the DAs just actually get their discovery stuff together,
That's understood,
right?
Your Honor.
We wouldn't be here if that had been done properly,
I
right?
understand, Your Honor. Yes, but the statute that defendant is trying to invoke here is not the proper time. As quoting the statute here, the statute says that the defendant shall notify the court that he wants to waive discovery at arraignment or expeditiously thereafter, but before receiving discovery. As Your Honors mentioned, defendant had received discovery. A month and a half prior, he received...
Counsel, stop. Stop. The record is clear that discovery was received on the day of the plea,
Yes,
which means defendant never saw it. You realize that, right?
yes.
If you send defense counsel the morning of the court date, that defendant has not had the benefit of what you sent. That's the truth,
Okay,
okay?
yes.
Now, it doesn't excuse no motion for withdrawal 3 months later, which is why you're hearing me say what I'm saying,
Yes.
okay? But giving discovery on the day of the plea does not satisfy the statute.
Okay, Your Honor. The fact that defendant did not review that additional discovery that was sent that morning did not invalidate defendant's plea for a couple reasons. Defendant had received all substantive discovery a month and a half before the plea and came to...
Who gets to decide what substantive discovery? The DA's office or the defense attorney?
It was the DA's office that sent...
No, it is the defendant attorney who gets to decide what's relevant evidence, not you. You must just give all that you have. You don't get to decide you need this today and that tomorrow.
Yes,
So
and
that's not an argument that's winning the day.
okay. And the defendant, a week before even the plea proceeding, wanted to plead guilty in this case based on the evidence that he already had. And that showed that the counsel had enough information about the case to try and negotiate an offer with the people.
Was there anything in that late discovery that would have turned the whole case around?
If there was, defendant could have brought that up during the October 4th proceeding after he saw it, or during the sentencing, or during the motion to withdraw his plea. He never did. As for the Boykin rights, just...
Well, the fact that they admitted jury with jury trials, not fatal.
Yes, exactly, Your
And
Honor.
Terrell makes it clear that you don't have to go through every single word of a plea.
Exactly, Your Honor.
And the fact that they missed the right to confront witnesses is not fatal either.
Exactly. You took the argument right out of my mouth. If there are no further questions, I'd ask that you affirm. Thank you.
Thank you. Counsel, you have a minute.
Yes, Your Honor. Mr. Walker could not have been expected to object post proceedings because he did not know about this right under 245-75. There was no way that he could have
Can you
known.
address the preservation argument? Because that's the one that's most concerning, at least to me. Just tell me why you think that it's still preserved.
Yes, I would point this court, preservation was not required here. There was no practical ability to object. I would point this court again to the decision People v. Smith, where there's a mutual
My colleague mentioned
misunderstanding.
that this was adjourned 3 months for for the defendant to spend Thanksgiving with his family. So why wasn't there sufficient time?
And at those proceedings, they were all about the predicate adjudication. The court called those proceedings a mess. And I would just ask this court if you determined that preservation was required to review this in the interest of justice because this 245-75 right has not been explored by any appellate court besides in Dicta and People v. Hewitt.
Thank you.
Thank you.
Thank you both. Ellerby versus 61 West 62nd Street. Hello.
Good afternoon, Your Honors. May it please the court. My name is Jeffrey Borokoff, attorney for the appellants. Just a couple of quick points. This is the case where the plaintiff was entering an elevator, the elevator door.
We all saw the video.
Yeah.
You did see the video.
So tell us, you know, they say that a picture is worth 1,000 words. That video was worth 1,000,000. So explain to me why you're here.
Well, we're here because the lower court ruled that the video was inadmissible, even though it was never issued or it's never raised as an issue.
Didn't the plaintiff herself authenticate that the video was an accurate indication of what had happened? I mean, she authenticated herself, correct?
She did. I believe that's at page 177 of the record. They asked her, is it accurate? They
So
said
that
yes.
on the basis of that, that should have been admitted.
Yes,
And once admitted, that would be dispositive of this case.
that's our argument.
Okay.
If there's
I
no
think
other
we
questions-
got your argument. Can I reserve your time for rebuttal should you
Yes, you
need
can.
it?
Thank you.
Thank you. So, counsel, welcome to this court. And so I ask you, that video is a slam dunk against your client. Your client testified she was in the elevator when it happened. She wasn't. She sticks her hand. The tips of her fingers don't even get around the corner of the elevator door. So it is clear that there was no malfunction here. She put her hand in a closing elevator door.
Well, Your Honor, I would argue that there can be more than one contributory negligent, more than one proximate cause to this accident.
What's the other proximate cause?
That the door was
That the door worked like it was supposed to and closed?
well, that the door was closing too fast, and that
There was nothing too fast about that door closing. Again, we all saw the video, separately and together. And the video is clear as day.
I would,
Your client is contradicted. Your client's EBT testimony is contradicted by the video. That by itself is enough for us to go in the other direction.
well, I would argue that the defendants had hired a company to overlook and
Van Dusen, I'm sorry, I didn't
Van
mean to cut
Dusen,
you off.
correct.
Van Dusen, you're relying on that.
Yes.
But if you read the documentation or their position carefully, they did not say the elevator violated any protocol, any state.
Well, it says
federal-
that it
just
vi-
give me a second.
apologize.
They didn't violate any protocol. They had their own standard, which is, in a sense, self-serving for them, but that doesn't mean that meant the elevator was too fast based on the every other person's standard here, and you never contradicted that.
Well, I would argue that it wasn't just their standard, it was part of the industry standards that they follow.
And who established that it was an industry standard?
I mean, that's what it states on what they have. It says acceptable standards for this equipment.
That
Keynotes.
acceptable standards doesn't say these are industry-wide standards that are recognized in the business.
Well,
I don't have an expert that says that.
plaintiff's expert does discuss that the ADA, which is, again.
The ADA is irrelevant because she was not disabled, and the ADA standard is absolutely not relevant here.
That's a red herring.
Well, the ADA is.
It's a red herring. She is not disabled. So that doesn't apply to her.
Well, I would argue that it is federally accepted and looked at.
And what
Is
did
she
you provide?
disabled?
No, it is not, but it's part of the totality of the circumstances
What
of this case.
documentation did you provide that shows that that is the applicable standard in this case?
Well, our expert, plaintiff's expert, discusses.
All right, thank you.
Who went and inspected the elevator 8 years after the accident, correct?
That is correct, but he also looked at the records that showed that less than a month before the accident, there's a work order by the
Did he
elevator
look at the
company.
video?
Yes, he did.
Okay, and he still gave us that opinion?
Correct, because it closes
Okay.
too fast for where the call button is located.
All right, thank you.
Unless the court has any questions, I'll rest.
Thank you so much. Justice Backer versus Abilis.
Good afternoon, Your Honor. Michael Wolk of Law Offices of Michael B. Wolk.
Hold on, is there someone here with you?
No, there.
Oh, okay, let's get him up live. That's why I'm confused.
No.
All right, you with us? Can you hear us?
Yes, I can. Thank you.
Okay, so he's gonna speak first, and then I will let you know when it's your turn, okay?
Thank you.
All right, you may proceed.
Yes, thank you, Your Honor. Michael B. Wolk for the Law Offices of Michael B. Wolk, PC. Counsel for myself as a non-party appellant. Mindful of this court's time, I'm happy to answer any questions the court may have. If it does not, then I would just respectfully rely on my brief, subject to a 1-minute rebuttal.
Counsel, you remain the escrow agent throughout, correct?
No, that was resolved as part of the stipulation of discontinuance with prejudice and release in August 18th, 2017.
Right, but you remain the escrow agent.
No, that was resolved as part of that.
You weren't discharged as the escrow agent pursuant to this stipulation?
Well, I mean, we don't have a factual record on this, but the negotiations that I had with Mr. Bellis's counsel indicate that we were.
What does the
I
record
have the
show?
stipulation, I have the stipulation, that's part of the record.
Yeah.
Did you
the
move to
record
withdraw as escrow
Hold on
agent?
1 minute, hold on. What the record shows and what we have in the record is what we have before us.
Yes,
So I need you to argue your argument based on that record,
yes, well.
okay?
I have a-
And what we have is that you remained as the escrow agent. You settled with regard to the action, right? But you remained as the escrow agent on the monies that were still in controversy.
No, Your Honor, as I submitted,
Who was the escrow agent then?
I was,
You were.
and the stipulation,
And you remained the escrow
No,
agent.
no.
and
Who became the escrow
Who
agent?
became the escrow agent after the settlement then?
no, as part of the release was intended to, and it said, release all of his claims against me personally and as escrow agent. So the necessary consequences of him specifically and expressly releasing me in my personal and escrow capacities is that I'm no longer the escrow
So does
agent.
that mean, in your mind, that because he released you, and I'm gonna look at it again to see if it actually says that, but assuming it says that, I'm gonna go with what you're saying, that it releases you as the escrow agent. Do you think that that means that you can ignore a court order that tells you to do something?
Your Honor, on,
I need you to answer my question, yes or no? Because your agreement with the litigants here has nothing to do with a court order. So tell me, do you think that if a judge says to you, you are the escrow agent, and I am ordering you to release that money to X, that you have a right to do something other than what the court said?
if the court lacks the power to issue an order against a non-party.
Did you file an order to show cause and say, Judge, I can't do that because I'm no longer the escrow agent?
I did file.
Based on the 2017 discontinuance, which released me as escrow agent?
Did file.
And was it granted? Did the court say you were right?
The court did not address my jurisdictional position. That's correct. It denied my motion to vacate on the.
Which meant that you had to follow the order. When they don't grant your order to show cause to vacate an order, that means denied, and you must now follow the order. Did you follow the order?
If the order was issued with
Did
jurisdiction.
you follow the order?
I did not follow an order. I
Okay.
contend was issued without jurisdiction because no court has power to issue an order
And
against
that's
a
your
non-party.
argument, and we've got it. You may be seated, and now I will hear the other side.
Have these,
Thank you.
the stipulation. It's not in there.
All right, before we stop, it says, I'm going to read the stipulation into the record. Plaintiff's Law Office of Michael B. Woke, MBW firm, hereby discontinues, waives, and releases its claims herein for legal fees against defendant Alejandro Ables, with prejudice and without cost to either side. 2, Abilis hereby discontinues, waives, and releases his counterclaims herein for damages and other relief against the MBW firm with prejudice and without cost to either side. 3, Abilis hereby discontinues, waives, and releases his third-party claims herein for damages and other relief, third-party Michael B. Woke with prejudice without cost. The MBW firm and MBW confirm that they are not litigation counsel for the plaintiff counterclaim defendant J.S. Barracket's firm, or the third-party defendant Sammy Barracket's, AKA Sonny Joseph Barracket's, in this action, and they will not subsequently act or seek permission to act as litigation counsel for the Barracket's firm and Barracket's in this action. Nowhere does it say that it releases the other issue. So you can respond in rebuttal. You may proceed, sir. Mr. Abilis.
Yes, thank you so much. Good afternoon, Your Honors. My name is Alejandro Abeles, and I'm the pro se respondents. I respectfully ask this court to confirm the lower court's judgment in full. This appeal is a bad faith abuse of proceeds, part of a 7-year pattern of delay. First, the lower court decision was correct, and this appeal is improper. The core issue was decided in December 2020 when the court ordered Mr. Walk to pay me the escrow funds. He is years too late to appeal the decision. The 2023 contempt order was correct because he willfully disobeyed that 2020 order for years. The 2024 sanction was also correct. It was directly response to his bad faith conduct. Second, this appeal is the final step in long, hard, harassing pattern of delay. Instead of obeying the 2020 order, Mr. Walk spent 4 years filing pointless delays. For example, delay number 1 in 2022, after getting an unfavorable outcome in the Justice Baker case, Mr. Walk tried to remove this case to the federal court, claiming lack of jurisdiction, when he is the one that started the case in the first place. He was denied by the federal court, he appealed, and his appeal was dismissed. Number 2, in 2023, he filed a new identical lawsuit in the state court. The judge in this case, Judge Waterman Marshall, dismissed it and stated on the record it was a bad faith attempt to avoid unfavorable decisions. Third, the timing of this appeal shows its real purpose. Mr. Walk did not appeal against the 2020 order. He filed this appeal only after he was held in contempt and sanctioned, the order that finally forced him to pay a judgment that is now 4 years old. This appeal is not about fixing a legal mistake, it is about delay. Finally, this abuse has caused severe real harm. Because of these repeated pointless actions, I could not longer afford my lawyer and was forced to represent myself in the duplicate case and in this appeal. This case has blocked funds I was awarded to rebuild my life after Hurricane Sandy. Your Honors, the lower court decision was correct. This is a final bad faith attempt to avoid a judgment. For these reasons, I respectfully ask this court to confirm the lower court decision in full. Thank you for your time.
Thank you. Counsel, you have 1 minute.
Thank you, Your Honors. This case arises from the fact that I represented Mr. Bellis on 4 litigations for which he paid me 0.
Can you answer her question about you being released as an escrow? Because I'd like to hear that, if you don't mind.
Yes. All right. He released me on all of his claims, and all of his claims in the case were against me as escrow agent and personally.
Does it say
Doesn't
that?
say that.
It says he released all of his claims against me personally. It does.
Personally, but not as escrowee?
Well, I would respectfully submit that under the court's precedent, and it was my understanding at the time, and if Your Honors see it differently, I will clearly comply with the order. I believed in negotiating with Mr. Bellis's counsel that if he wanted to separate out any issue about me as
The
escrow,
court ordered you to give this money to this man. And you unilaterally decided that the court had no jurisdiction over you, that the court was wrong, and that you weren't going to listen to the court.
that's not true.
That's exactly
I
what
didn't
happened here.
unilaterally decide. I believe that I.
Counsel, you're an attorney. If you wanted to remove yourself as escrow agent, you would have included that in the stipulation of discontinuance. It's not clear, no.
All right, well, Your Honor, I believe that just like we isolated out one thing for the continue into the future with Mr. Barkatz, that's why it was consistent, why we didn't isolate anything out. And, I do have, okay, if this court concludes that that I should have specifically included an additional provision as to an escrowee, which that's fine, then I'm happy to comply with the court's order and pay the money immediately. I honestly did not believe that was necessary. I honestly, in good faith, believe that releasing claims against me on claims that were in my escrow capacity.
You were going to unilaterally make that decision, not seek an order from a court to say that that court was wrong asking you to.
I did. I made a motion to
You just
vacate.
decided, I'm not going to do it. Thank you, sir.
But I did make a motion to vacate.
Thank
I
you.
did,
And it was denied.
and that, yeah.
And then you failed to do what the court order said. Thank you. $239 East 18th Owners versus Wade, and I'm not angry, so please come on up.
Did you skip US Bank? You skipped US Bank.
Okay, I'm sorry. US Bank, I have to do US Bank first. I called you out of turn, you're next, okay? And the same thing goes for you. I'm not angry. Don't mistake my passion for anger. Just a little passion. We all have some. How are you?
Good afternoon, Your Honor.
Wonderful. Welcome to this court. You have 4 minutes, sir.
Thank you. May it please the court, Mark Kruger, Butler, Fitzgerald, and Fiveson for the appellant. Just real briefly, I mean, this case boils down to the issue is, should the interest of justice intervene to relieve a party that's at fault of judgments? And we don't think it should.
Well, at least let them put in an answer and respond on the merits. 2 of these were default judgments, right?
Well, I would say no. I mean, we've already obtained those default judgments.
But the
They're
issue,
now vacated.
that's the issue before us is not the ultimate merits, right? The issue before us is whether the court improvidently granted the to vacate the summary judgments. That's the only issue before us.
The only
So we're
issue.
not going to look at whether down the road you'll be successful, right? That's not what we're looking at.
Agreed.
Okay.
And our point is that the interest of the court abused its discretion in using the interest of justice here, because the party that's seeking relief was partially, if not largely, at fault.
But that's the merits.
Well, that's not the merits.
That is the merits. You're saying you're a stupid businessman. You should have been paying attention to your businesses. That's what you're saying. And so you may not have said it as indelicately as I did just now, but that's what you're arguing, and you may be right. And that argument may be successful, but that's not the issue we are deciding.
But I believe it is, Your Honor, in this sense. There was no reasonable excuse for the default. That's already been found. The only reason why they vacated these judgments are in the interest of judgment. And I don't think it's appropriately being applied. And I'll put it this way. When I was thinking about this, the LLCs are the respondent, correct? We all know that they're the LLCs. Arguably, the LLCs, through their sole manager, which Christopher, the father, appointed his son as the sole manager, those LLCs, in fact, defrauded Appellant. If you believe everything he says.
And again, I think that that is a great argument on the merits down the road. The issue here is, right, whether it is so unreasonable in the interest of justice for the court to think, wow, this father has been blindsided by a son who has been disloyal and lied and tried to steal from the entire family. So, in the interest of justice, should this man not at least be heard?
Not when he's in fault. Not, our point
Again,
is not when they're in
there
fault.
is nothing in this record that tells me he knew.
Well, but
Now, should he have known is a different issue, right? That goes to the merits of you're not being a good owner, right? That's to the merits.
But I would say
Right?
this, in the cases that we looked at, in the cases where interest of justice is invoked, the party is blameless, completely blameless. They did nothing wrong. Here, the distinguishing factor is.
So here, his blame is what?
That
He's
he-
a loving father who trusted his son.
That he put his son to be the sole
He
manager.
loved his son and he trusted his son not to betray the family.
Okay.
That's what we got here,
Okay.
right?
But there's a,
I mean, tell me that I have something different.
Well, there is
'Cause that's what I see.
there's one-
I see a son who has gone off the reservation, mortgaged the family's holdings up to the hilt, pocketed that money, and lied to his family. That's what the record I see.
but the son was put in that position
I
by
agree.
the father.
So that was a stupid decision,
The other nuance is this.
obviously.
One other nuance, and I'll close with this, is the articles of organization are clear. That it's to be managed by one or more managers. And obviously, the son was acting as the manager. Then you extrapolate that to the limited liability law, which says that if it is to be managed by one or more managers, the member, in this case Christopher, who's driving the litigation, really doesn't have any say. So frankly, I think it could be argued that only Francis could have put forward a defense to these foreclosures. He was the only person in a position that could do that. And he was put in that position by Christopher, who's coming to this court now asking for the interest of
But yeah, but
justice to bail
it's
him
a
out.
father and it's a son. I mean, you have to look at the specifics of the fact. He's a retired FDNY. He gets these properties. He puts his son in charge, and this is what happens. As Justice Mansonet Daniel said, might have been a very stupid business decision, but let's at least give him an opportunity to make an argument on the merits, and I think that's what Judge Gomez decided in his decision, that there's some interest of justice there.
And I understand all that. I do.
We'll have time on rebuttal. I understand where you're coming from, okay? I really do.
Good afternoon, Your Honor. Mark Alonso of Alonso and Thatcher. I'm sorry. A little time
Counsel,
barely
can
is
you
worth
pick
it.
up? Can you pick up where your
I
friend
actually would
left
like
off?
I have 2 points I'd like to make because time is short. The first is that Judge Gomez's interest of justice decision not only was right, it's certainly not an abuse of discretion. I'd point out 2 things. On the facts, it's like a television commercial, but wait, there's more. The things you mentioned were not limited. Not only was the son a bad son, and did all
He created a false operating agreement. How would the father know that? If we know,
Well,
I don't
more
know.
than that, then when all the house of cards starts to come down, he goes out and hires a lawyer who comes in, puts in a defense. And I will say, Judge Gomez in his decision, it's a long decision because he had to navigate the same problem we had as attorneys. We're looking at this going, wait a minute, these judgments are past a year. 50-15 is going to give us a problem with that. Number 2, if it's a default, there's actually, and even in doing, by the way, hiring a lawyer under false pretenses, he even did that badly by hiring it only on one case. So I have 2 defaults, 1 contested judgment. I've got to go back to the judge and explain it's not technically a default. It's also, you look at 50-15 and say, well, maybe I'll go and move to vacate on the grounds of fraud. But every case involves fraud by the plaintiff securing the judgment, not.
But your friend argues that Christopher should have known this.
And that ultimately is going to be an issue. And that touches on another issue, which they use the word manager. And he says, oh, well, he was a manager. First, it was Mr. Christopher's, the father's wife, who was just collecting the rents. These are bungalows on City Island. We're not talking about a 250-person apartment building. That's number one. But a manager of an LLC, and that's going to be an ultimate issue, is a different thing than a resident manager, an office manager. Your Honor used the word superintendent, which I actually have been chastised for using because they are now called resident managers. But that is something Judge Gomez is going to have to decide, is when you put someone in charge of a couple of bungalows because your son can't keep a job, does that make him a manager for purpose of mortgage? I don't know. It's an ultimate issue. All my client is asking is that, having weaved his way through the fact that it wasn't fraud by the plaintiff, it was over a year on defaults, and then we said, okay, but there is a traverse needed. We did the traverse, and Judge Gomez noted, okay, and then I'll deal with the interest of justice argument. We did the traverse, certain facts came out. We didn't try the whole case, didn't talk about the fact that the law that a lender must exercise due care when lending to an LLC. And that is going to implicate those ultimate issues that Judge Gomez is going to.
Judge Gomez just felt that in the interest of justice, Christopher should get an opportunity to fight this on the merits.
Yes, that's it. And I'm just saying that the reason we went back on re-argument is because he said, gosh, you lost the traverse hearing. Too bad you didn't move on interest of justice because I might have granted it. And we said, but we did, Your Honor. And that's why it's a re-argument. Thank you for your time.
Thank you.
Thank you.
I'm going to give you his leftover 20 seconds.
Not to belabor it. I mean, just the real point is I don't think the interest of justice should be invoked to assist someone who is at fault at the expense of someone who's completely innocent. To say he wasn't the manager, who nobody else was. He was doing all the work there. And I just don't think this is a proper invocation of the interest of justice. I think that's reserved for someone who's completely blameless, that had nothing to do with it, and it's certainly not to be used as a sword against someone that's innocent, obtain their judgment.
Well, the case ain't over. You're still going to be able to make that argument. Thank you so much, gentlemen.
Have a nice afternoon.
And now 239, East 18th Owners Corp. versus Wade and Elige. I'm sure I'm messing that name up, but you'll correct me when you get up.
I am Mario Eligiu, pro se appellant. Good afternoon.
Good afternoon.
We are appealing the dismissal of my unpaid wages counterclaim, which is presently, which was in the lower court case, which is ongoing.
Sir, and you amended your complaint to include that, correct, sir?
Yes.
Sorry,
Sir, would you agree that the court conflated the issues before the board? Let me restate it. The fact that you were an independent contractor does not mean you're not entitled to the wages for the services you provided.
Yes.
Correct? It's really that simple.
Yes.
And the court made a mistake here.
They did.
And you're entitled to get paid those wages.
I am.
And they have not really challenged the work you perform.
They haven't.
So we're good.
Any more questions?
No.
We'll save your time in case
Thank you.
afterwards, okay? Yes.
Thanks.
All right. Counsel?
May it please the court, Ripka
You can sit down here.
You can stay here.
Ripka Jar, Colbert Law for the respondent. The decision of the Unemployment Insurance Appeals Board, it must be given res judicata effect.
How is that they determined, the sole issue that they determined was whether he was an employee or a independent contractor, right?
Correct. That is
They
true.
did not settle the issue of whether he was
He's owed
properly
money.
paid,
That is correct.
correct? So that means that it is not res judicata because that issue was not determined.
They're using the term, and I understand that they're pro se, they're using the term wages as in salary, which is different. That's what an employee gets. An independent contractor gets paid
All right.
according to his contract.
So let me break this down for you. When someone works and you receive a benefit, they should be paid.
Correct.
Okay. And we know that he was not fully paid for the work that he did. We agree on that, right?
Yes.
Okay. So whatever term you want to use to describe what he is owed, he's still owed.
And he needs to make that claim in his counterclaim.
Well, he has
did.
Doesn't he, didn't he amend his answer at some point? They amended their answer to assert, I guess that first cause of action was also in the alternative for quantum merit, for that he should be paid for any services that he performed as an independent contractor. And that's what he's looking for.
If we look at the facts that he recites in his counterclaims, he always says he's an employee. And he says, I want to be paid my wages as an employee. I understand it's semantics, but it makes a difference.
Right. And so we are not going to get caught up in
No,
that.
we're not going to.
No, I understand.
We are not. So I need you to argue about what it is your clients believe they owe him or don't. You can continue to engage in this repartee about how we describe it, but at the end of the day, he performed services for which he was not paid, and he is due. So why don't you address that?
Well, that will come up, and we're going through discovery right now to see what was done and what wasn't done. There's
Right.
an issue there. There's an issue there, but it's not wages. If we call it wages,
We're
then-
not going to call it wages. We're not going to call it wages. I think we're going to put that in our decision. And I think that's a good point. We'll make sure not to do that, right?
No more further questions. I rest on my brief. Thank you very much.
You were going to do the rebuttal, right?
You don't have to.
If you don't think you
don't
need to,
have
you don't have to.
No, I'm just trying to form a thought. Haven't yet. My time's not up, though. Kathleen Wade, co-appellant. Collateral estoppel and res judicata are very big, serious concepts. When they're applied properly, I'm sure they save the court and the society time. When they're applied wrongly, they can do enormous harm. One of the things that bothers me about how this has been conducted by our opponent is that the evidence for what occurred in the UIAB, which is in the reproduced record, fairly detailed. There are 2 documents, one's 5 pages, one's 9. Of course, a lot of it's boilerplate, but saying what we plan to consider, and then a report of what the testimony was, and then a detailed 4 or 5 point decision. Why does our opponent never cite to those documents? It seems because it supports our side of the case and does not support their side of the case. And instead, what our opponent seems to me to be doing is asking the court to to shut this down on the basis of collateral estoppel, which would interfere with us getting our due process, based on their say-so, not based on any evidence, not based on a single document. And that concerns me. And so we ask the court to reject collateral estoppel, to return the case to the lower court for the first and only adjudication of my husband's wage claim.
Thank you.
Thank you.
Thank you so much.
Thank you.
Preti versus J.J. Hoyt.
May it please the court.
Yes, good afternoon.
I represent the plaintiff, Allison Preet. In my limited time today, I would like to address what is surely the most important issue legally, and that's the duty owed, if any, at common law to maintain the sidewalk. I think my adversary and I agree that when you have a landowner who is not a special user of the sidewalk, there's no duty to maintain the sidewalk unless a statute imposes it. There is a duty to refrain from making it worse. Now, if, on the other hand, the owner specially uses the sidewalk, it was constructed for his or her benefit differently, then, according to the defendant, the duty is exactly the same. It makes no difference. The duty is only to refrain from making it worse. Now, I know, and I cite a number of these cases at pages 41 to 43 in my brief, that this court in the second department more than often than this court, has conflated those two of those standards, special use and causation, into one. I'm going to set, and this court has done it too on occasion. I'm going to, if I get through them all, give you 5 reasons why that is wrong. First and foremost, because the Court of Appeals said the opposite and has never said, no, we were wrong. It's the trustee's case, where the defendant in that case made exactly the argument that's being made here. Prove that I made this grate that was installed in the sidewalk for my benefit worse. That's our only duty. And the court said, no, that's not the case. Your duty is to use reasonable diligence to keep the grate in repair. It has to be as safe, suitable and safe for the public to walk over as any other part of the sidewalk, number one. And in my brief, you'll see, although that's a very old case, the Court of Appeals has stated it exactly that way. 3 exceptions, not 2, 3, again and again. 2, while, as I've indicated, this court has used the conflated standard, it has also used what I would say is the correct standard, the Court of Appeals standard, repeatedly, and the roots go deeper. This goes way back to the Nicholsburg case, which is cited in our brief. More recently, it was the Petty case of 2010. Nicholsburg was in the 40s. It was exactly the issue here. And this court ruled, no, you've taken the sidewalk for private advantage. You have a duty. I'll talk faster.
No, I don't want you to do that. You see, there's only one more, and so forgive me, gentlemen, but I don't want you to rush through your argument.
Thank you very much, Your Honor. Thank you.
And I will afford the same courtesy to your colleague.
Thank you. Third, while, as I've said, there are cases that state the law as the defendant would have it, here's what you won't see in any of those cases. The Court of Appeals, that's not the law anymore. It's changed. What happened, obviously, is at some point a court conflated those two standards, the two of the exceptions, to make 3 exceptions, statute, special use, causation, turned it into 2. And so a month later, the court picks up the same standard again and again. But what you won't see in any of those cases is that's no longer the law, what the Court of Appeals said, because they don't consider those Court of Appeals cases. They don't go back even to the cases this department said, stating that standard. Fourth, the conflated standard is utterly illogical. It's like saying, as we mentioned in our brief, one exception is if the defendant causes the defect. Another exception is if it causes the defect on Tuesday. Another exception is if it causes the defect with a hacksaw. It's still causing the defect. And what you've done is you've taken the special user exception to non-liability, and it becomes surplusage. It's meaningless, because if you created it, then it would fall within the special user as they frame it. If you haven't, then it wouldn't. The last reason is policy. What you look at when you see cases like trustees, and I'm going by what you said, Your Honor. When you look at trustees, this court's decision in Wiley, this court's decision in Nicholsburg, what you'll see is, here's a quid pro quo. You're using a portion of the public sidewalk for your advantage. And in some instances, including this one, the public's going to be disadvantaged. There were no parking signs in front of this driveway. And you're saying...
It was a three-car garage, right?
Correct. No parking signs in front of the three-car garage on the street.
Do you need a parking sign in front of a three-car garage? A three-car garage is a three-car garage. They're for cars. Everybody knows this. I don't need to be told that.
Yeah, I guess it's a redundancy, Your Honor. But,
right. So not a requirement then?
No. My point is only that here you're taking something from the public. Absent your driveways, I could park there. Because of your driveways, I can't.
But that's not the issue here, right? Here it's not whether you could park there. Here she was walking on the street, correct?
Could you address, there's another issue that I was also concerned about, and it's the whole thing about the LLC and whether or not the fact that, can the LLC reside at this premises?
Your Honor.
Since this is a particular LLC made up of two members, their husband and wife, they live there with their two children in this property. Does that?
Yes, Your Honor. Despite what we said below and on appeal, we are not contending that a corporation or an LLC can't get the benefit of the sidewalk exemption.
So you're resting the crux of your argument then on the issue of the special use?
No, Your Honor. Those are alternative arguments, and I'll tell you why. All we are contending is that if you create a corporation, you can't pierce your own corporate veil if you find the corporate form inconvenient.
And what case says that in this context? Because we have cases that have held that a corporation could absolutely take advantage of this. And so the one case that you rely on is a Kings County lower court case, which is not binding on this court.
Your Honor, we are not saying a corporation cannot take advantages of the statute. When you look at their motion papers, they're the movement. And you look more specifically, look at their argument at page 356 of the record. There was not only was there no proof that this LLC, a separate legal entity, resided at this address, there was no claim that this LLC resided at this address. The claim was, because we're the owners of this LLC, husband and wife.
I thought the record showed that this LLC was created for the explicit purpose of buying this building.
That's correct.
Right? And so I don't know of any case law that says that if you as an individual create an LLC and purchase a building that you choose to reside in, that somehow exempts you from being able to take advantage of this statute.
We're not saying it does. What we're saying is...
Can I interrupt for a second? I think you're making a technical argument.
I'm sorry?
I think you're making a technical argument.
That's correct, Your Honor.
That the corporation, sorry, not the corporation, the LLC does not reside at 126 Way Street. Is that your argument?
Almost.
So let me understand.
No, I'm very close to it. Our argument is you're the movement seeking summary judgment. You must prove.
So they haven't demonstrated that the LLC resides at 126
resides there. And
So
you will see from the record.
Because I don't think there is anything that contradicts or even controverts the fact that this couple created this LLC to purchase this very building, right? So if that was the entire purpose of creating the LLC, then I don't understand the argument. Then if I say, I created this LLC to buy this building, I now live in the building with my family, and I rent one of the units out, and I reside here, and that's the only thing we do here, is reside with the tenants. I don't understand.
Let me try.
Please.
The Secretary of State, this entity, LLC, filed with the Secretary of State that service on it would be made in Liberty Street.
Yes, that's their service company, and we know that. So what?
So you have to make some showing that this LLC.
They're living there. What else do they have? They live there with their children, for God's sake. What else do they have to do to show that this is, that they bought it for the intention of residing there? They reside there with their children. They rent one of the garden unit, and they rent the garage spaces. I don't get it.
Okay, I'll leave it at that, Your Honor.
Okay.
I mean,
I'm not trying to beat you down. Because you and I have lectured together, so I know what's in that brain of yours. I'm trying to understand.
if the horse is dead, I'm going to stop beating it.
Yes, my colleague wants to ask.
Mr. Schut, I need to understand the nuance of the special use issue. My understanding on this record is that Mr. Beal, the husband part of the member of the LLC, testified without any real contradiction that the sidewalk driveway to the three-car garage pretty much was exactly the way he got it. In other words, the way you see it now, the way it was, is, and will be. So A, he didn't contribute or cause or create the so-called flag misleveling that occurred here. B, there's nothing from your side that suggests that their use of the driveway caused this misleveling. So, and my understanding of special use is you have to show that you created the defect when you started using or doing special use here. So that we get the point.
What you'll find, I believe, Your Honor, and there's no two sides of this. Special use runs with the land, the Court of Appeals had said. In many, many instances, the special use was sometimes in antiquity. No one remembers who created it. There is law, Your Honor, to the effect that if it was created by someone else and you don't use it, then it's no longer your special use. The testimony in this case, uncontradicted, they do use it. They use it themselves, they use it for their tenant, and they rent one out. I guarantee you, Your Honor, you will find it runs with the land, the duty, and therefore, if the prior owner constructed it, it's your special use. There was one last issue in the case, and that was assuming for the sake of argument that we have to prove not only it was a special use, but the other prong as well, you caused it. There were two dueling affidavits to the experts. Now, was our experts, Mr. Fine's affidavit, was that, yes, was that an exemplar of scientific work? Let me tell you, no, it was not. But
glad you agreed.
Thank you, Mr.
This court noted, I cite a case called Polanco, a decision by this court. And there, in another battle of the experts case, this court said, your criticisms of the plaintiff's expert are not wrong, but they would apply equally to your expert, Polanco. Here, they're the movement. They have an affidavit from an expert that cites no statutes, no regulatory standards, no non-regulatory standards, no scientific sources, no scientific articles. As a matter of fact, in a case that's about a defect, which this expert calls comparatively minimal, he doesn't have a measurement of it, which suggests two things. A, he didn't know, didn't think, oh, maybe I should measure it, or he did measure it, but didn't like the answer. Polanco, is what we would mainly rely on, and the fact that you'll see in our brief no fewer than 3 First Department decisions, Davidson, Weiskopf, and Wilk, where it was exactly this issue. Did the special use cause the defect in issue? And in all 3 cases, the court said, normally it's for a jury to weigh the conflicting, and in these cases, it is for a jury. Just with respect to this very issue, it's for a jury.
Can I stop you? Because the fine inspection, I think, occurred 2 years after the fact. So why would we even get into any of his conclusions if it has no basis in what occurred in 2019? And we know that the other, I think Mr. Schaefer's inspection occurred sometime in the same year, in 2019. So how do you rebut the Schaefer affidavit when your client's expert inspected it 2 years after the fact without any ability to show it was similar to the time of the accident?
Your Honor, to make it worse, it wasn't similar to the time of the accident.
I know that. I know
Right,
that. 'Cause they fixed it. I know that. I'm saying, how do you even get in the fine affidavit? It's, as a matter of law, it can't be used.
Well, again, I would Polanco you, Your Honor.
Okay.
Thank you. Thank you. Counsel, I will give you your double time.
May it please the court, my name is Matthew Cuomo. I represent J.J. Hoyt. I'm not sure what order to go in, but I'll start with what I believe is the most important issue on this case, and that's the issue of the scope of the duty. We agree that there's a special use. There's a curb cut, so that's the special use of the sidewalk. It allows the cars to traverse the sidewalk. And we agree that there is some duty in limited circumstances for those property owners, in this case homeowners, to fix what is caused by the special use. And this is not new law that I'm suggesting. This is the law as it has been for 150 years. And I want to go right back to that trustees case, trustees of Canandaigua, I think it is. What does the Court of Appeals say there? They say to keep the grate in repair, not the sidewalk, not even the sidewalk around it, but to keep the grate in repair. That was the special use. And that's the way the special use claim has always been formulated.
But here, the grate is the sidewalk, no?
But it's not, Your Honor. The
So
special,
what is the equivalent grate here then?
it's the curb cut itself. And there's no allegation that the curb cut is in disrepair. But I want to draw back from that.
Counsel, he's using the entirety of the sidewalk, not only the curb cut. Isn't that illogical?
No, it's not illogical, Your Honor.
That doesn't make any sense
But
because, wait. 'Cause a curb cut introduces you into a path. It is the path that is at issue here. So the counsel, that is a red herring if I've ever heard one, okay?
Adopting your position, Your Honor.
No, you're not adopting my position if you say that the curb cut is the issue. The curb cut is not the issue. If there is indeed a special use, and I heard you just admit that there was, right? Then the issue is the sidewalk that is being used to access let me finish, I'm still talking. If the sidewalk that is accessing the garage has been impacted by the repeated weight of cars going back and forth, then that's the issue, not the curb cut.
Drawing back one step, Your Honor, the first issue is the causation. So at common law, those abutting landowners have absolutely no duty to maintain the sidewalk. They have no duty to inspect it. They have no duty to maintain it. We have 2 major exceptions to that. First is actual creation. Second is special use. Notwithstanding what Mr. Schutz says, we're not trying to conflate them. We're not trying to make one eat up the other. I could have a creation, just by way of example. If I own a home in Queens and I go out and I decide
How about you tell me what in the record establishes that there is no issue of fact about the condition of this sidewalk vis-a-vis the garage access? It seems to me that that's the issue. So do your papers provide a expert that unequivocally says that sidewalk that accesses the garage were not impacted, were not affected in any significant way?
Well, Your Honor, I will answer that question. I'm going to read to you from my brief, but I want to step back a second, and I want to get...
I don't want you to read from your brief, because I already read it.
I'll paraphrase it, Your Honor.
Okay.
What I'm trying to get to here is, I could create a condition on a sidewalk. I say, for instance, I am changing the oil on my car in the street, and I spill oil all over the sidewalk. I've created a condition. I'm not making a special use of that sidewalk. I just happen to drop all the oil from my car on the sidewalk. I've created a condition. When it's a special use, the special use has to cause the condition, and here they're claiming that there's a misleveling of the sidewalk. The special use has to cause the condition either by the special use itself. A perfect example of that is sometimes you'll have like an oil fill cap that protrudes above the sidewalk and somebody trips over that. There's no dispute. The special use is the defect itself, like the grate or the coal chute in some of those older cases. Or the special use of the sidewalk somehow degrades the general sidewalk around it. And what the plaintiff is arguing is that we have a general duty to repair in that case. But the law is clear. The plaintiff has to demonstrate that the special use, either itself or by its use of the sidewalk, has degraded the sidewalk. That's the difference we have on the law. Okay. On the facts.
Can I stop you? Because I think it's in the reverse. I think you have the burden on a motion for summary judgment to show that it's not a special use.
Well, you're agreeing it's a special use. You're just saying that there was no damage caused that correlates in a proximate cause way to the plaintiff's injuries.
So can I?
Is that your argument?
Yes, Your Honor. Okay. And Mr. Schaefer, who examined the sidewalk, I believe he examined the sidewalk before it was changed.
Correct.
And Your Honor, we don't address the issue of the size of the offset because we're not moving on a de minimis defect. I'm not contending that the defect as it was or that offset is actionable or not. I'm saying that the unequivocal evidence, which was not rebutted by the plaintiff's expert, demonstrates that the special use did not cause this defect, whatever this defect is, this offset. And how do we know that? Because Mr. Schaefer applied basic engineering principles to the evidence that he had. What was the evidence? There's no linear cracking in the direction of travel over the sidewalk. He says in his affidavit that you'd find linear cracking if the sidewalk was being degraded by the cars. What do we have from Mr. Fine? He doesn't mention that. He doesn't contest that linear cracking is an indicator that the special use, the curb cut, is causing the defect. He doesn't do that because he can't do that, because he cannot rebut that, because there's no science or engineering that supports that position. Mr. Fine spent a third of his affidavit talking about how he reads the law. There was no science there. So that's the first piece of evidence, no linear cracking in the direction of car travel. The vertical offset over which Ms. Preet claims she tripped was located adjacent to the deteriorated fiberboard expansion joint. And Mr. Schaefer was very clear. He described how that expansion joint can deteriorate two ways: by physical damage because of the cars driving over it, and he says, I find no evidence of that. What does Mr. Fine say in response to that? Not a thing. He leaves it unchallenged. So that's the second piece of evidence that demonstrates absolutely no indication that the special use causes this defect. Instead, he says, and again, Mr. Fine doesn't challenge it, Mr. Schaefer says, that fiberboard expansion joint, like they all do, over time degrades and wears away under the weather, which can happen anywhere, not just at a special use. And three, I think I've already covered this, he talks about, and again, not rebutted by Mr. Fine, that there's no evidence that the fiberboard expansion joint was damaged or dislocated as a result of the special use of the sidewalk, driving the cars over the sidewalk. So when we get down to it, whether you look at the issue of causation, as Justice Hagler said, as my burden as a movant or as plaintiff's initial burden in order to formulate the claim. Either way, we win because there is no dispute, and Mr. Fine does absolutely zero to rebut that affidavit by the architect that this was not caused by the special use.
Thank you.
I think I have a couple of quick points. First, for Justice Shulman, this is at page 33 of our brief. We cite this court's decision in Martinez-Robles, 2018, stating that the area of special use runs with the land as long as it's maintained for the benefit of the special user. Said the same thing this court did in Bonaventura, and we know that decision's right.
Can you address your adversary's arguments with regard to your expert's failure to contradict the declarations made by their expert?
The support for their expert's statements of fact was that he said so. There was no authority of anything cited, scientific or otherwise. Mr. Fine.
Can I stop you? Didn't Mr. Schaefer go into great detail in his affidavit stating they were along the line of where the traversing of the cars, there was no path of cracks, which would indicate that the weight or some other external factor caused the defect in the sidewalk?
Your Honor, what Mr. Fine said.
I'm talking Mr. Schaefer said that, but.
Yeah, I know that.
Okay, I'm
What
sorry.
he said in response, Your Honor.
Correct.
The weakest part of the sidewalk is where the joints meet and the flags meet. And according to their expert, it's just a sheer coincidence that that's where the defect was. And Mr. Fine said, essentially, there's no scientific basis for that. Two cases I cite in my brief.
He doesn't explain how come there are no cracks, right? Because when there is too much, either a driveway doesn't have a sufficient thickness of cement or has not been properly rebarred so that the cement stays together and is able to withstand expansion and contraction from weather, right? Which is why we have the joints, right? To allow for the cement to expand and contract to the weather. There was no discussion about why there were, one would expect to see linear cracks in the direction of the direction of travel of the driveway, if indeed the driveway itself, the cement, could not withstand the weight of the vehicles traversing the area. And there was no evidence of it, or at least none indicated in the expert report, to contradict what your adversary's expert says. And our case law says if you don't controvert.
To both of Your Honor's points,
Okay.
you are factually correct. What Mr. Fine said is you've not cited anything, there's no scientific basis. You are factually correct in what you just said. We do cite in our brief.
Can I ask you one more question? Because it seems that you have trying to create a standard that's a little different than I'm accustomed to seeing, or maybe there are other cases out that I haven't seen, that you're saying the general duty of the plaintiff that's making a special use is tantamount to a duty that to maintain the entirety of the sidewalk, absent nothing being wrong with the method in which you're using the special use, or let's say cars going over the sidewalk. Are you saying that? Because I thought you said that.
First, now, if I'm not saying it, the Court of Appeals has said it, and this court has said it. But what the court said is no, the fact that you have a driveway or you put a water cap or something doesn't make you responsible for the entire sidewalk. It makes you responsible for the area of the special use. And when you look, and that's it. That's the trade-off.
What is the area of the special use? I know my colleague asked you that
It's a
question.
driveway.
I wasn't sure. The entirety of the driveway is the special use?
I mean, he says it's just the curb cut. I mean, and you're saying it's the whole thing?
You'll see a lot of cases involving driveways.
Yeah.
You will see no cases saying that only the front portion of it counts.
Okay.
Because it's not very useful. Without the rest of it, you can't get to
Yeah,
the
right,
garage.
curb cut, yeah, kind of. Good
Can I follow up with one more question? 'Cause I'm not sure if I got the answer to the question. Because let's assume for argument's sake that the entirety of the sidewalk is a special use. Are you arguing that absent some contributing factor to make a defect in the sidewalk, that there is a duty that's general rather than some causative factor?
And that's the last question.
Yeah, I'm sorry.
No, no.
I didn't hear the answer. I didn't
It's
really hear the
okay.
answer. I apologize.
Please tell me if I'm not clear. We are saying that with respect to the area of the special use, yes, you have a duty. It's not just you have to refrain from making it worse. Okay. You have to keep that as safe as the rest of the sidewalk. And I'm saying it because this court said it and because the Court of Appeals said it.
Now you said it clearly.
Where the argument that was just made is exactly the argument that was rejected in both cases. And as to my colleague's point that, well, there are still cases, you can have causation cases that aren't special uses. Yeah, you can. But under his theory, you can't have special user cases that are not causation. It's one is subsumed in the other. And every court, including the Court of Appeals, that said there are 3 different exceptions. Special user, you caused it, and a statute places it on you. Every court was wrong. There's really only 2. Thank you, Your Honor.
Thank you.
And last but not least, and gentlemen, thank you for indulging us.
Thank you.
You're welcome. Archdiocese of New York versus Century Indemnity. You tell everybody I gave you extra time now.
A lot of extra time.
A lot of extra time.
Thank you, Your Honor. Thank you for granting our request for argument.
Yes, you are welcome. You may proceed, sir.
Anton Metlitsky for the insurers. So the current version of Section 3101F is substantially different from the version in effect when this court decided Clarendon in 2009, because the legislature amended the provision in 2021 in a way that makes clear that it applies only to insurance policies, as it says, not to reinsurance contracts.
It doesn't say it doesn't apply to reinsurance contracts.
It doesn't, but it says it applies to insurance policies, and then it
Right,
defines.
and a reinsurance policy, a reinsurance contract is a reinsurance policy for an insurance company.
I don't think that's right,
Oh,
Your Honor.
yes, it is.
So I disagree, Your Honor. So their main point is that, you know, we have said, and a lot of people have said, that reinsurance is insurance for insurers, and I think that is a colloquially correct way or analogy of describing
It's
reinsurance.
insurance bought by insurance companies.
It's not insurance bought by insurance companies. It's when one insurer cedes a portion of the risk that it has written to a policyholder.
You can describe it whichever way you want, it's the same thing.
Well,
I'm gonna insure you for part of your loss. Insurance.
So I think the important point, though, is that when the legislature uses, the question is,
Did the
important question.
legislature omit reinsurance from their statute?
No, but when in other places, when the legislature intends for a statute to apply both to insurance and to reinsurance, it explicitly says so. We made that point in the brief without really.
Counsel, doesn't it say in 3 different places, any insurance agreement? It said it 3 times, I think, in the statute.
Well, it says.
So why isn't a reinsurance agreement?
They could have said other than reinsurance agreements if they wanted to exclude it.
They could have, but
And
the
they
question
didn't.
is, sure, but I don't know why the burden is on them to exclude it when in other circumstances, when they want to include reinsurance, they expressly include it. Let me give you one example. So
That's fine. The fact that they included somewhere else doesn't mean that they should not have excluded it here if they wanted it excluded. When you say any insurance contract, that means any insurance contract, including reinsurance
it
contract.
doesn't say any insurance contract alone. It says any insurance agreement in the form of a copy of an insurance policy, which we don't think includes reinsurance, and then it goes on to define what it means by insurance policy, and it says all primary, excess, and umbrella policies, which are terms that just do not refer to reinsurance, as we showed in our brief. I think the definition of those terms is insurance written to policyholders, and then it also talks about other things
Give you
that.
30 more seconds.
Thank you, Your
You'll
Honor.
have a minute on rebuttal.
Another thing that has to be included in the insurance policy that is disclosed is the name of a claims adjuster. There's no such thing as a reinsurance claims adjuster because reinsurers don't adjust claims. This whole statute is focused on insurance exclusively and not reinsurance. And
Thank you.
Thank you.
May it please the court, Jared Zola from Blank Rome for respondents. Record page 287 states, quote, reinsurance is simply insurance for insurers. That's what Chubb, the appellants, said, admitted in their briefing before Special Discovery Master Richter in this case, and they did so citing Court of Appeals precedent. This court held the same in the Clarendon case in 2009, compelling disclosure of reinsurance agreements under CPLR 3101F. And the 2021 amendment that my friend just mentioned to the rule via the aptly named Comprehensive Disclosure Act didn't change the words under which Clarendon was decided requiring disclosure of, quote, any insuring agreement. The amendment is not a limitation at all. What the amendment does is it elaborates on the types of information and documentation that defendants must now automatically disclose at the beginning of a case. And in subsection little I, it's all primary, excess, and umbrella policies. And it goes on to say contracts or agreements. And then subsection II also says in the conjunctive, and II, if plaintiff won't agree to accept mere declarations pages, then defendant or counterclaim defendant must disclose full, complete copies of any policy, contract, or agreement. And I believe all of those words encompass reinsurance agreements, but the word agreement is particularly important here because appellants refer to their own reinsurance as, quote, agreements throughout their briefing to this court and in their 10K to their shareholders and to investors, which is at record sites 218 to 224 in this record. The language of the rule we submit unambiguously encompasses reinsurance agreements, and the court doesn't need to look to legislative intent whatsoever. But if it does,
And the thing is, the statute, the 3101F was amended in 2021, which was after Clarendon was decided. So if the legislature thought that they should be addressing the problem raised in Clarendon, that would have been a perfect time to do it.
Justice,
Correct?
I think you beat me to the punch. That was exactly the next words out of my mouth.
I read your mind.
You sure did. It's a fundamental tenet of statutory construction that the legislature is presumed to know, to be aware of decisional law existing at the time. And if the legislature amends a statute without directly rebutting the judicial interpretation that exists at the time, they are deemed to adopt it.
Because we know sometimes they do change the law immediately after a Court of Appeals decision because they just don't like it and they make a change. And they just don't.
And they did make an exception for no-fault insurance, correct?
That's exactly,
Yes.
that's exactly
So
right.
as was pointed out, they could have made an exception for reinsurance, and they didn't.
Exactly right. 3101 F5 makes exception for certain motor vehicle.
Right, no fault.
And I believe it was an incumbent on the legislature, if they wanted to make this exception, to do so expressly. As appellants make the point, the legislature knows how to use the word reinsurance when they want to. They say that ad nauseum in their brief, and they just don't do it. I believe it's a bit of a stretch to say that the amendment to this rule in any way excludes reinsurance. Having not done so, I believe they fully adopt and accept the reasoning in Clarendon and the Anderson case in the Fourth Department. Thank you.
You have 1 minute, sir.
Thank you, Your Honor. I just want to make 2 points. First of all, in terms of knowledge of Clarendon, there was Justice Branston wrote an opinion in 2010, 1 year after Clarendon. It was called Mount McKinley against Corning, 2010, Westlaw 6334283, which said 3101F does not require disclosure of reinsurance in coverage case, which means that there was a dispute. And the whole point of this amendment, per the
That case
legislature.
appealed?
I'm not sure, but I'm not saying it's binding on anybody. I'm just saying that if the legislature was aware of one, it was aware of the other, and the point of the statute was to clarify what needed to be disclosed. The second point is, I think the basic dispute is, when the legislature uses the words insurance policy, does it presumptively include reinsurance or exclude it? And our main argument, I think, is that it presumptively excludes it, because in other provisions, when it means to include it in the term insurance policy, it says so. So for example,
How should we perceive the fact that they took the time to exclude no-fault insurance, but didn't include reinsurance?
because no-fault insurance is insurance. So of course, if I'm right that it applies to insurance, then they have to exclude no-fault, otherwise it would be included.
Thank you.
Thank you, Your Honor.